This is Do It For a Living, your source for inside information on the future of automotive performance.
I would probably suggest kind of doing an internal audit of your own information and see is there anything unique that you've come up with, maybe that you haven't publicly disclosed yet, where you might want to try to file on a patent to try to help grow your business.
What's holding you back from starting or growing your business into what it can be? Well, if you're listening to this, it's not a lack of information. What you're about to hear is all you need to get motivated and start making waves. Do It For a Living podcast details the journey of today's true players in their own words. Find out how they broke out so you can too. The time is now. The time is always now.
Welcome back. This is going to be a fun interview here today. So sometimes we have gotten into business topics, and this is one of them that has been on a lot of people's minds, and is always an issue that people have. You don't want to deal with it until you need to deal with it, and then when you need to deal with it, you need the proper help to work with it. And what we're talking about is patents, of course. So if you make a product that is something that is unique, you're going to want to patent it. And how do you do that, and what kind of course do you take? And so Brian Mack is with us from Lathrop Gage. They are a law firm here, and it's throughout the U.S. I believe they got several offices, and he is the guy that was at SEMA, and that's actually where I met him and their marketing person, which is Katie, who we'll be working with in the future here. So, Brian, how are you doing today?
I'm good. How are you?
Good. So, Brian, I wanted to get started. You wanted to first say that this information that we're providing is for educational purpose, and it's not actually attorney-client relationship for any listener. So, for people listening, if you do have any questions, you still need to seek your attorney or contact Brian separately. So I think that's important to say, and you told me to get that out there so people aren't using this as actual legal advice.
Yes, very good.
Good.
Thank you.
And before we get started, I also wanted to say for our listeners, we have a new webpage up for the doitforliving.net is the webpage, or sorry, that is the link. On the new page, we've got several new things. We have new blogs, so it's not only just a podcast landing page. We have several blogs for tools and equipment and software and just general information that can help your business grow. So now that we've got that out there, check it out, doitforliving.net. Okay, so Brian, back to you. Let's get started on this thing here. So why don't you first give us a background of yourself, who you are, where you are from, what got you into law?
Okay. I grew up actually on the East Coast. I am originally from Columbia, Maryland, just outside Washington, D.C. area, and never really intended to be a lawyer or a patent lawyer. I grew up wanting to be an astronaut and wanted to go into rocket science. And so growing up there, it was kind of a fascinating area to grow up and seeing some of the things and historical landmarks and stuff like that. But went on to college in North Carolina. I attended engineering school at North Carolina State University in Raleigh, North Carolina, where I received my engineering degree in Aerospace Engineering. While I was in school, I did an internship with the Department of the Navy at Marine Corps Air Station Cherry Point, where I was working on the Harrier fighter jet. From there, once I graduated with my bachelor's degree, I accepted a position with Pratt Whitney in West Palm Beach, Florida, where that was their headquarters for designing their military jet engines. And I was a part of the F-35 Joint Strike Fighter, which is the latest and greatest fighter jet to join the military, capable of supersonic stealth and vertical takeoff and landing. After spending some time working there, I was convinced by my boss at the time to move over to a new company that he was starting called Power Systems Manufacturing. And they specialized in providing aftermarket spare parts for gas turbine engines for big power plants. Unfortunately, about a year into that business, we were sued for patent infringement by General Electric. And so that's where I got my first taste of patent law, and actually found it to be very fascinating despite the stress to it. It was a very fascinating area where you could mix engineering, science and law together. And so I worked with the attorneys heavily in that case, helping in various aspects of the case to support them, their efforts, and was kind of a key part in that whole process. And it was an eye-opening and educational experience, and kind of convinced me that this may be an area I want to move into. So after a few more years working there, that law firm actually convinced me to move out to Kansas City and offered me a position working for them, kind of in a similar capacity that I was doing for the engineering company. And so I spent a number of years with them, where at the same time while working, I went back to law school at the University of Missouri, Kansas City. So I now have my law degree and have been out practicing for a number of years, working as a patent attorney. And I've done some legal work for a variety of companies, everything from some software to some telecommunications, but I spend most of my time in the mechanical area, including having done some work for some of the big three auto manufacturers, as well as a number of smaller automotive companies.
Okay. So you are, and I don't know how many of our listeners actually know this, but a lot of patent attorneys do come from a very technical background, because it's pretty much required to be able to write these patents that you're having to not only just write, but you have to defend it and make sure that people understand it, and cover a broad range of areas on that. So technical background, and you're an engineer working in defense, and then the law firm brought you on and as the engineer, though, not as a attorney, right?
Correct. In order to practice patent law, you have to, as an attorney, of course, you have to have passed your state bar exam. But to practice as a patent attorney before the Patent and Trademark Office, you have to pass a separate bar exam administered by the Patent Office. And to even be qualified to sit for that exam, you have to have a number of hours towards a science or engineering degree, or actually have a science or engineering degree.
The place you're at right now, that is the company that I guess you went through law school for?
No, there was I'm at my second firm here in the Kansas City area.
Okay.
I was at a first firm in town, then I went back to law school, and now here with a different firm, with Lathrop Gage.
Got it. Okay, so give us an idea of what kind of bad experiences you can have in law. I mean, I would assume this is all over the place as far as some weird things go on at the patent office, right?
Yeah, there's in terms of some, say, bad experiences maybe, or some stressful experiences. I'll go back to the story I was talking a little bit earlier about when our company was sued when I was working as an engineer, and we were sued for patent infringement by General Electric. We were a smaller company. GE is a huge company, and it was a true David versus Goliath type case where it was literally bet the company on this litigation.
Okay.
And what I mean by that is that if we didn't win, the company was going under. And so patent infringement and patent cases can be very expensive and very time consuming, and can be life-changing in the aspect, depending on what happens, in the outcome of the case.
And were you vested in that company, or just an employee of them?
I was just an employee, but we were a very small company, so there were only about 30 employees at the time, 30 or 40. So everybody was very well vested in it, because in maybe not ownership stake, but future employment stake, definitely.
Okay. And so what's something you like about working in law?
What I like about the field of patent law especially is the opportunity to still keep my engineering skills to a certain extent, and to be able to keep my mind thinking like an engineer sometimes, to see some of the more high-tech advancements that are coming out. A lot of times we see things very early on in the development stages from some of these companies prior to them hitting the market.
Okay.
So it's a fascinating way to kind of stay still plugged in technically while still being able to practice law.
And you said you're doing a lot more automotive stuff now. Are you still doing any defense, or does it just kind of run the gambit on mechanical patents that you're writing?
It probably runs the gamut. I do a lot with the power generation industry, not so much in the defense area anymore, but more in power generation, transportation, and then in the automotive areas.
Okay. And what's something you're doing right now that has you fired up?
Well, work is very busy. The field of patent law has been great that for the most part it's been recession proof, and so a lot of companies really value their intellectual property, so they spend a lot of time and a lot of resources on it. And so in terms of being fired up, it's just there's a lot of things going on, and so it's just a very busy place.
Cool. Okay, so before we get into the focus topic, which of course is patents, we need to distinguish a couple of these different things. So there's obviously patents, there's copyrights and trademarks, and then there's also like litigation and I guess your legal issues with like waivers and stuff. And these guys over at Lathrop Gage have agreed to do a kind of a multi-part series with us. And so we're going to just cover patents today, but look for it in the future here. We're going to be covering the copyrights and trademarks, and then we'll probably do another one with litigation as well. So that's kind of we're going to kind of break this down into 3 separate topics so we have a resource for each individual one. Okay, so Brian, why don't you go ahead and tell us about Lathrop Gage and what is it? Where does it operate? How many lawyers do you guys have?
Okay. Yeah, Lathrop Gage is the oldest law firm in one of the oldest law firms in the Midwest. It's headquartered out of Kansas City, Missouri. We have 10 offices that stretch from coast to coast, from Boston all the way to Los Angeles, and we have just over 300 attorneys practicing, but we are a national multi-practice law firm, and by that we mean we have everything from tax folks to wealth strategies to intellectual property to business litigation to product liability. So we run the gamut. And so by being a full-service law firm, we can be a one-stop shop essentially for your legal needs.
Awesome, and that's exactly why you guys attend SEMA as a I guess a marketing technique, is looking for those shops and manufacturers that work in this industry that may need all kinds of help, right?
Exactly. Yeah, we approach it. We bring our mechanical team from Lathrop Gage in the intellectual property group, because that's primarily our focus is in the intellectual property area, protecting patents or protecting your inventions with patents, as well as your business marketing needs through trademarks and other intellectual property. But we do have the ability to help on a number of different aspects, whether it be business formation, tax issues, liability issues, things like that.
Okay. And as we move on here, I kind of wanted to, Brian and myself have talked about 2 examples that one of them is made up and one of them was actually, I think was one of our listeners' actual case. But the first one, and these examples we're going to use to kind of explain some of the ins and outs of patents. So I have a imaginary power filter. I'm going to call it the power filter. It is an air filter that separates the nitrogen from the oxygen and allows the oxygen to pass into the engine but blocks the nitrogen out. My imaginary air filter gains 30 to 40% power on any engine when you tune it for it, and there's nothing like it ever made. Totally unique product. The second one we're going to use is an aluminum control arm for a car that normally comes with stamped steel control arms. So it's a similar product, but made with a different material, maybe a slightly different design. So the product is unique to this car, but obviously there's aluminum control arms on other cars. Other people make different control arms for different cars. So it's not a new product per se, but it is unique to this specific make and model. So those are our 2 examples we're going to use through this interview here. Okay, let's start with the most obvious one here. Patenting a product. Tell us the difference between a design patent and a utility patent, and where would these 2 examples fall into?
Okay. A design patent is literally like what the name is. It covers what its name says. It covers the design, or really the ornate design to something, where a utility patent will protect more the structure of it and how it functions. So, for example, a common design patent in the automotive industry is oftentimes on more the surface body of the car. So this could be like your taillights, your headlights, the things that have a different kind of ornamental shape to them. Whereas a utility patent would cover more the functionality of, say, a headlight. Maybe it's a system in terms of how it automatically turns on at a certain darkness outside, things like that. So the design patent is more to the look, and it's limited to exactly the look that is just depicted in the design patent. So if you make any slight modifications to it, you can get around a design patent. So in scope, the design patent is a lot narrower than the utility patent, as the utility patent is covering more the components that make it up, as well as its overall operation.
Okay, so likely our control arm example would fall under a design patent. The control arm could be covered by a design patent, but something could also have, that control arm also has a utility function to it, so it could be the subject of a utility patent as well. Okay, so you could do both. Okay.
Yeah, you could do both. So, for instance, the design patent would cover the shape of the control arm, maybe if it's got any curves or certain features to it, where the utility patent is going to cover how it's assembled, possibly, or what it's made from, as well as its function.
Okay. And then the air filter, that one would probably want to focus on the utility part of that because it could be a lot of different shapes and a lot of different sizes. But you want to cover the general, what it's doing is more important than how it looks.
In that case, yeah, it would be more important to cover that from a functional standpoint and what it does as opposed to how it looks. Because you're right, you could have a filter that could come in a variety of shapes and sizes. And so you'd be easy to design around something like that.
Okay. And there are a lot of different parts to intellectual property laws. Can you kind of explain the different areas of them?
Yeah, there's four main parts to when we say IP or intellectual property, what that covers. The first and one of the biggest areas is the patents. The second is copyrights. Third, trademarks. And fourth, trade secrets. And patents are covering the idea or concept of something that you've come up with. So this would be, like we talked about, the control arm, the power filter, things like that. A copyright is covering an original work of authorship that's recorded in what's referred to as a tangible media. And so in that way, we're talking about a publication, a book, an owner's manual, a website, and that also stretches to cover things like musical recordings, other artistic forms of expression, paintings, photographs, things like that. Those are all covered under copyright protection.
I believe software falls under that one as well, right?
Software can fall under that, but software can also fall under a patent because the software. Now, there's been some recent changes in the law regarding software patents and the extent that how broad they can be covering things. But patents do cover software as well.
Okay.
And then the third part is the trademarks, and the trademarks are really covering your business branding. So that's your logo to your company, your slogan, things like that that differentiate your product over somebody else's product by way of how it is marketed and in the marketplace. And then finally is trade secrets, and that is exactly kind of what it is talking about. Information to your trade or your business that you take the necessary steps to protect as a secret. Some of the most famous trade secrets are things like the recipe for Kentucky Fried Chicken or the ingredients in the recipe that form Coca-Cola. Those products have been out there for a while, but they've preserved the secret in terms of some of the special ingredients to make it what it is. And so those fall under the classification of trade secrets.
So is trade secrets you don't apply for that, you just don't tell people that. Is that how that works?
You don't apply for it, but you have to take the steps to protect it. So in the business world, some ordinary trade secrets include things such as contact lists, maybe mass media mailings in terms of who your customer lists are, things like that you're protecting because it provides a competitive business advantage to your business. Those would be covered under trade secrets.
Okay, that's something. When I worked at Lockheed Martin, they had a lot of, whether it was a trade secret internal or if you patent it, because if you patent something, you got to explain it, right? That's kind of the reasoning of it?
Yes, exactly. When you patent something, you're giving the information over to the public in exchange for that exclusive right that's granted by the patent. Whereas a trade secret doesn't have an expiration date as long as you maintain the secret and you take the necessary steps to maintain the secret.
Okay.
So there's certain areas of your business where you don't necessarily want to file for a patent because you're going to want to have that protection basically for longer than the term of a patent. And other times you do want the patent instead of trying to protect something as a trade secret because you're going to sell it. It's going to be out there in the public. And so for things like that, you'd be looking at trying to file a patent on it as opposed to maybe internal processes that you follow through. Maybe you have in your shop, for example, a way of repairing a component that is done in a proprietary way that you don't want to put out there by way of a patent, but because it provides you with what will be a longer term business advantage.
Okay. So that one's a little bit harder to understand, but it's basically you're not filing for anything. You're just protecting it internally, and you don't have any recourse against other people if they start doing the same thing, right?
There is recourse in terms of typically trade secrets and the recourse happens when you have an employee that leaves your company and
Gotcha.
takes certain business information with them to a competitor and, for example, says, well, what we did at shop A was we did something this way, so we can just do it here. And now they've jumped over certain hurdles to get immediately to the final result, and they didn't go through the necessary steps to figure it out themselves. They did it by way of a secret that was carried from one company to another.
Okay. But if somebody on the other side of the earth came up with this exact same thing on their own, then there's no recourse on that one, right?
Correct. Yeah.
Okay, so what is a provisional patent application? And then there's a different one. Well, what is a full patent application? And can you explain the differences between the two?
Certainly. A provisional application is effectively a placeholder in the patent office. That provisional application is a little bit more informal. It doesn't have to include certain sections that are required in a full patent application. And it can be done to basically get what's referred to as a filing date in the patent office. And so if you're kind of under the gun to hurry up and get something submitted to the patent office, because maybe you're going to start selling your product soon, you would maybe consider filing a provisional application. It can be done quicker, it can be done cheaper, and then it gives you 12 months from which then you have to complete and file the full patent application. Now, a full application is known in the patent office as a non-provisional application, and that has all of the requirements to it that are required by the examiners so that the patent application can be examined and can eventually issue as a patent. So it costs a little bit more to do. The filing fees are a little bit more, but that would be the actual document that then is examined at the patent office.
Okay, so the provisional patent, is that what is typically called like patent pending? Or
Well,
both
actually,
of them under that?
They're both under that. So whether you file a provisional or a non-provisional, once they're filed in the patent office on that date, then you're officially what's referred to as patent pending.
Okay. Recently, the U.S. patent law underwent some overhauls, and they changed the U.S. patent system from a first to invent to a first to file system. So that is where it's important when you have actually began the patent process, like when you have filed this thing. So can you kind of explain that? How does it change things?
Yeah, generally, under the old system, you used to have up to 12 months from the time you publicly disclosed your invention to then file your patent application. So you could come up with your invention, start selling your product, and then as long as you filed within 12 months, you were still okay for obtaining a patent. Now, other countries were always under the operation of you had to file your patent application first. So it was a first to file as opposed to what's called first to invent, which was the old system. And so the U.S. changed their laws a couple years ago to really conform with more international standards, where we would now have effectively, it's kind of like a race to the patent office. Instead of later on proving, well, I invented something first and kind of backdating and showing when you started to develop your invention, now it's more when the application is submitted to the patent office that's the critical date.
Yeah, and I remember I think when I was in college in 2000 and early 2000s, I remember people you'd want to write dates and basically timestamp your notebooks because that was what back then was important for patents, right? Like that was what they're trying to teach you in school, was to date things. So if you ever had to go back to it, you had it documented, correct?
Yeah, I mean that's kind of how the older system was operating. Now, still having all those dates and information is still very critical, but now it's more trying to get your patent application in first to the patent office.
Okay. And so between our two examples here, between the filter and the control arm, I mean, what would you be doing for either of these, like a provisional or the full patent? Kind of give us an idea of what path we would take with each of these.
I think it would kind of depend on how far along down the road you are in the design process and what the business needs are. If you're ready to go to market with it, and you're getting ready to, say, go to SEMA or go to a trade show and make an announcement about a certain product, you may consider just filing a provisional application just to make sure you don't make any disclosures that could potentially bar you from obtaining a patent. If you still have some time before you're going to be offering to sell it or making any public disclosures, and you have a little bit more time on the patent side, you would probably go through the route of drafting the full application, because there is probably a little bit of a cost penalty that you would be paying by doing both the provisional then the non-provisional, just because of some time lag between the two applications. Each have a filing fee that's required by the patent office. And so if you can get away with just doing one application, that's probably the better approach. But sometimes it necessitates filing a provisional before then later on filing a non-provisional. Now, there is actually also, on the flip side, there is a business advantage to just going with the provisional first. And that is, it gives you the patent pending statement prior to you going out and marketing. You can do it, like I said, for a lower cost initially, but then it does buy you 12 months time frame to kind of figure out, does my idea have some business advantage? Is it going to take off? Are people interested in buying it? And it also gives you time to kind of develop it a little bit further. So you don't have to necessarily lock your design in place and then realize, oh, this isn't going to work. I don't want to pursue this anymore. And you've invested a lot of time and money into the patent side.
Okay, so the provisional patent only is good for 12 months from when you file it? Or is it from when it's processed?
It's good for 12 months from the date you file it. So if we were to file one today, we'd have 12 months from today to then file the non-provisional, or the provisional application then goes abandoned.
Okay. And then the full patent, how long do those last for?
The full patent is good for 20 years from the original filing date, from the earliest filing date. So in the example of where we filed a provisional and then we follow it up with a non-provisional, we would be 20 years from the filing date of the provisional application.
Okay, so the first time it was sent to the office.
Exactly,
okay.
First time.
Okay, and so in our examples here, like our power filter, sounds like if we were ready to bring this to SEMA right away, and we wanted to we already have a booth set up, but we haven't patented it, we would go for the provisional because it's also quicker to apply, and the office gets back to you quicker with that one. Is that correct?
Well, the office gets back to you just in terms of saying we've received it and here is your filing number, but the office doesn't do anything with it because it's never examined. So in that case, if you realize, for example, you're getting ready to go to a trade show and you're going to announce a new product and you realize, oh, we haven't filed for patent protection on it, and the show is on Thursday and it's Tuesday, you could conceivably get a provisional application filed in quick order to go ahead and get that date and time done before there was any public disclosure.
Okay. So they're not looking at it and comparing it against other patents. That would be more the responsibility of the lawyer doing the application, not the people in the office saying, there's something already like this out here,
Well, the patent office does do that analysis when they examine the non-provisional application.
Right, exactly.
Yes.
But not the provisional one because they're not looking at it.
That's right.
Okay. What should someone consider patenting in a product? What are you looking for to patent? And would either of our two, what would you patent on either of our two examples?
Okay. Well, first of all, a lot of things can be covered in a patent. Like we talked about earlier about a design patent versus a utility patent, you could opt for a design patent if you've got certain ornate features about the product that you're selling. Maybe it's a design to it or a certain shape to it. So you could look at it from that, just from the aesthetics, to see if there's something you want to cover. You could, from a utility standpoint, you could look at it from its operation, how it operates. You could look at it from the different components that make up the system. So in the example of the filter, you may have something like a housing that then has a filter material inside it. Maybe it's got some sort of framework to keep the filter material in place. And so you could have a patent that kind of covers the overall system. And then maybe you also would then have some claims to how it operates. And that would be more towards like the method of filtering air. And then you talk about some of the features in terms of how it operates.
Okay.
And so those are some different areas that you would consider patenting, like in the filter product.
Okay. And then the control arm, it would be, I would assume you're just looking for the design, like the shape and the it's not really the construction of it, right? Because that's something that's already covered under somebody else's utility patent.
It could be, but if you've maybe made some advancements in terms of how you would construct it, maybe it's a casting process versus a machining process or something like that, there could be some utility aspects to it that would be beyond the design. I would just suggest that you want to protect it from a number of different ways, because you want to, the goal of it is by being granted a patent, you're getting a right to exclude others from making this or selling it in the marketplace. And so you want to look at, well, who potentially could be trying to take my design? Maybe it's a manufacturer, maybe it's a distributor, maybe it's a user. And so you want to look at trying to patent it from a number of different angles so that you can try to get the maximum protection possible.
Gotcha. And you kind of mentioned processes, and that's manufacturing processes. That is also falls under the utility patent area, right?
Yes. Yeah. Under the utility patent, you can have claims that are written towards the structure or a system. You can also have claims that are written towards a method of doing something. So like a process, maybe it's a method of manufacturing, a method of repairing something, along those lines.
Okay. What kind of time frame and costs are associated with patenting a product typically?
The cost is a difficult thing to pin down because it really varies depending on the technology. A provisional application, like I said, is a lot cheaper than a non-provisional just because it's usually quicker. It's a lot more informal in sense that for instance, your drawings could be photographs, whereas in a non-provisional application, the patent office has specific drawing requirements that have to be followed. The time frame for it, provisional can be done as short as in the same day sometimes. Ideally, the more time you have and you give your attorney to work with, the better quality application you're going to get that will more accurately cover the product you're making or selling. A non-provisional application, depending on the technology, if somebody were to sit down, may just take a few days to write and be uninterrupted and just write it for a couple of days. But typically, a non-provisional application can take on the order of 30 to 40 hours to prepare.
Okay, so like a solid week of somebody writing this. And for people who have not read patents, some of them it's very, I don't know, for lack of a better term, dull and like boring to read, but it's very lawyer speakish, right? Is that's kind of the...
Yeah, that's a good way to put it. They do have their own... They're in the English language, but they do have their own nature to them in terms of the language that's required. And you can write it yourself. People have done that and have been successful at it. However, the patent laws are very thick and there's very detailed requirements. And so oftentimes it's better to consult with the expert about what it's going to take to go through. I've had a few clients that have come to me who tried to write it themselves and then they get rejected by the patent office and they don't really know how to respond. So working with somebody who understands the ins and outs of patent law from the beginning really will save you time and money in the long run.
Okay, and you just touched on something that I think is pretty important to say is the patent office can actually reject patents. And I have actually seeked out patents on certain things that I've thought of, and from what I've been told, it actually happens a majority of the time. Is that correct?
It happens almost all the time. On a rare occasion, will you submit a patent application and be issued, and the first response from the patent office you get is the issuance. It does happen. I've had a few that have gone through that way, but a lot of times they don't, and that's because the examiners are looking to see whether your invention is novel and whether it's non-obvious. And they're looking through their database of records, and they primarily will rely upon other prior patents as well as published patent applications, whether that be here in the U.S. or similar documents overseas from foreign patent offices. And they're looking to those to see whether maybe there's a prior patent that teaches exactly what you're trying to claim as your invention, or whether if you take a combination of prior documents that were known and were out there prior to your filing date, whether if you combine those together, that would teach your invention.
Okay, and you touched on two other things here: novel and was it novel and unique?
Non-obvious.
Non-obvious. Novel and non-obvious. That is what the patent office is looking for to grant a patent, correct?
Yes, on a high level, that's the standard that they're looking for, the requirements that must be met. The law is a lot more detailed than that, but those are the initial thresholds.
Okay, and non-obvious means that what's an example? Can you give us an example of a non-obvious, or give us an example of an obvious thing that can't be invented, like a light switch with a button instead? Is that like I can't really?
Yeah, I mean, you could have where it would be obvious that their basic threshold or their standard is they take it and they say, would it be obvious to one skilled in the art? So in the automotive area, say you're talking about a wheel, would it be obvious to somebody who has that educational level that specializes in designing wheels? Would it have been obvious to them to have taken a patent on a wheel design with then some other patent on another component, would that person have known to have combined that technology together? And if so, then they would say that that would be obvious.
Okay, so we've kind of touched here and there on this, but say I'm going to bring you my my air filter here, and then we'll also bring you the control arm. Walk us through the basic procedures of what you're going to do with me to patent this product, and kind of give us an idea of the timelines for doing this stuff.
Okay. Really, for either one of these, it'd probably be about the same approach. If you bring the product, to us, or the design to us, we want to understand, what is your objective in this? Is your objective to make the parts? Is your objective to just obtain the patent protection on it, and then you really don't want to make the parts, but you want to sell? You want to sell a license to your patent to somebody to manufacture, or maybe you just want to sell the patent outright to, maybe it's one of the big three automotive manufacturers, or to a company to go produce it instead, and you just want to get a royalty out of it, or just payment for your work that you did. So we'll kind of understand what your goal is in the project. From there, we'll need to see a lot of the details to the invention. So whether that be an actual part, that's the best. In the mechanical world, that's the best thing. So for the attorney to be able to sit there and see it and look at it, and what the different features are to it, that's the best case scenario.
Okay.
But we'll also need a lot of the design details to it, in terms of, like, maybe it's the blueprints or some of your background design information. If you have any analyses that you've done on how it performs, all that kind of information is then kind of rolled up and put into the patent application. Now, we're not going to, you don't put, if you notice from the patents and the drawings, you're not putting blueprints in necessarily, because you're putting information in that is necessary for one of ordinary skill in the art to make or use the invention, based on what's in the patent, as well as their general knowledge. And that's kind of the threshold of the level of detail that has to be included in a patent application. It's kind of a gray area, because it varies depending on the technology we're talking about. But in this case, we would take all the information that you can provide us with, and the more details you provide the attorney with, the more efficient the attorney is going to be in preparing your patent application.
Which translates to cost for people who are
which
paying
translates to
attention.
cost, exactly. So the more information you can provide somebody like me with, the lower the cost is going to be to prepare the application. So because it's the fewer questions we have, and the just quicker we can put it together. And so what will happen is once we have that information, and we typically gather that information through either an in-person meeting with the client, or even a teleconference, where we'll go through kind of the invention, the questions, we'll understand the state of the art, or the background of, why did you come up with this invention? What was the reason for doing so? Maybe there was a problem with the existing product, and that drove you to come up with a redesign, which you've improved the system, and you've created some new features yourself.
Like our control arm.
Like the control arm, exactly. Or in the air filter case, maybe you were trying to improve the performance, and so now you've come up with a new air filter that now achieves this improved performance. So we would try to understand the background, and then we'll get into the details of your invention, and exactly how your invention is assembled, the different parts to it, how they interact with each other, how they interact with other components, say already in the engine, or on a car, or on whatever the component might be. And from there, then we'll get into the final section of the patent, which is the claims. And the claims are exactly what you are stating is your invention. And now that's where a lot of you talk about the language that's used. A lot of times the claims read, it's hard to understand what they're saying. And that's just because of how it's being described, to make sure all the different components are described correctly, and how their interaction, how they're interconnected or interrelated to each other. That's why the language of those claims kind of don't necessarily read in plain, ordinary spoken English. But those are the main sections to the patent application that we would put together. We'll assemble the drawings to go with it, the figures that would be necessary for one to understand the written portion. And the figures, aren't, like I said, they're not necessarily the blueprints. They're not going to have the dimensions on it or things like that, but they're going to point to the key features of the invention so that one would understand what this piece is and how it operates.
Some of these that I have looked at are literally hand sketches, like just a rough drawing of, like whatever product it is just a hand sketch. It's not like they're not printing off SolidWorks drawings. They're just rough drawings, right?
Right. And they can be hand sketches, at least initially. You don't have to file, formal looking patent drawings even with a non-provisional application. You can do hand sketches. The patent office will most likely object to something that's simple, and they'll require drawings to be then submitted that are in accordance with their standards. And that can be done at a later point down the road. So that's not a problem. Solid models, like I said, the patent office does have specific requirements about their drawings. Typically, they're black and white wireframe type drawings. Under certain conditions, can you petition to accept color drawings? A lot of those are used when you have maybe analyses showing stress levels on a plot or something like that.
Okay. So can you give us, our listeners, some pointers when seeking a patent attorney? And also what questions should they be asking to be sure they have the right person for the job?
Yeah, I mean, believe it or not, there's a lot of similarity between patent attorneys and, say, your mechanics that are working on automobiles. A patent attorney has specialized training, just like a mechanic does. They have specialized training beyond a regular attorney. And just like mechanics specialize in certain areas of the car. So, for example, if your car needs a tune-up, you generally don't take it to an auto body shop to get the work done. And similarly, when you're choosing, when you have a patent application on, say, it's a fuel injector that you've come up with for an engine, you're likely going to want to seek someone out who has a mechanical background, say, not somebody who specializes in drafting patents for computer software or telecommunications. Not to say that they can't do it by any means, because patent attorneys are very good at kind of brushing up on the skills that are necessary to understand a certain technology. But you also want to go to somebody who's going to understand your invention, because the more that they already kind of understand the technology from the beginning, again, translates to cost. The less time it's going to take them to prepare your application, which will save you money in the process. So as to questions that you would want to come to your attorney with, you want to understand a lot about their background, their education, and the type of work that they do. And a lot of that you may find on the law firm website. Most law firms have bios profiling each of their attorneys, and you can kind of see their education, their undergraduate education. They may even list some representative patents that they've written or clients that they've worked with. And so you can kind of see, okay, yeah, this guy, he really specializes in electronics, and I've got a new mechanical widget for the engine. This may not be the right matchup. Now, he may know somebody that he could refer you to, or he may be able to say, well, yeah, I specialize in electronics, but I've done a lot of mechanical type things too, so it won't be a problem. And so you just want to kind of get a feel for whether you feel like they're going to understand your technology.
That's awesome advice. And the nice thing about your guys' firm is, if you don't do it, I'm sure there's somebody there that can or has done it, right? Exactly.
Like I said, I specialize in mechanical type devices. I have done some telecom, some software. All patent attorneys have probably dabbled in different areas, but when they get down to it, they do probably have a specialty area where they tend to reside. But no, our firm has patent attorneys that specialize in all different areas, whether it be from environmental type issues to mechanical devices to software to everything in between. So,
all right, and this is the big question here. Can you explain the difference between domestic and foreign patents?
Sure. A U.S. patent is exactly that. It's only enforceable here in the United States. So if you have an example where you have a patent covering, let's use the air filter. You have a patent covering the air filter here in the United States, but somebody is knocking off your design, say, in China. They're making it over there, and let's just say they're only selling it over there. Your U.S. patent can't be used to go enforce or try to stop them from making or selling your product over in China. Now, you can get patents. That said, you can get patents in other parts of the world too. You can get a patent in China on the same air filter device that you have a patent on here in the United States. So something to think about when you're starting to try to protect your intellectual property is, well, where am I going to make this? Where am I going to sell it? If you're going to be making it over in China, because, say, for instance, with cost, that it's a lot cheaper to produce something overseas, you'd want to consider potentially filing for a patent application over in China as well to protect anybody from knocking it off and making it in another factory over in China.
Okay. And in the case of our control arm, like a lot of that stuff is manufactured in China. So you'd want to, it would be ideal if you're going to sell it in China to patent it there because it's likely that somebody would take that design and copy it, right? Is that kind of what I'm...
Yeah, no, you're right. If there's a case where you have something like that part, you would want to consider, if you're going to be selling it here in the United States, of course you'd want to go for your protection here in the United States. But if you're making it overseas, you're likely going to want to file for protection over there as well. Now, unfortunately, because you're now filing two applications, you're talking about additional cost that's associated with that. And so you really want to look at your business from a strategic standpoint and figure out where might we be making it, selling it, using it, and consider filing for patent protection in each of those countries, just to see that, so you can ensure that your product is as best protected as possible.
Now, does every country have its own patent office? Do you have to file like 300 patents to cover yourself worldwide, or is there like an international organization for this at all?
There is an international organization to start with. And so what you can do is you can file in the United States, but you can also file what's referred to as a PCT application, and that stands for the Patent Cooperation Treaty. And that is an international treaty that was signed by 150 different member countries. The United States is one of them, and most of your countries are members of the PCT. So all the countries in Europe, a lot of the major countries in Asia, even countries in Africa are all members of this treaty. And so what that means is you can file initially one international application that will have the opportunity to go to any one of these 150 different countries. And it gives you some time before you have to select which countries you want to go into, to kind of decide, again, like we were talking about earlier about the provisional and whether it's worth pursuing full patent protection, whether you want to go into each of these countries. And then down a little bit down the road is where you would go through and select which countries you would actually want to have your application examined in and try to get a patent. As part of that international filing, you get what's called an international search report and a written opinion. And it's kind of like a first pass at an examination from the international standpoint, where they would look at it, give you a sense for what prior art out there is similar to what you filed in your application, and you can make some initial changes to your application before you even go into these national country patent offices.
Okay, so you would eventually still have to start filing at the individual country level, but you can start with this international one as a kind of almost like the provisional.
Exactly. Yeah, you can do that route.
Okay, how does somebody protect a product made in the U.S. from somebody copying it in the other countries? Can you protect them with your patent in the U.S.? Like, if somebody makes it in China and they bring it in the U.S., what can you do? Do you sue the person that is selling it, or do you sue the person that's manufacturing it in China? I mean, how does that work?
You could go after the person who's selling it here in the United States, and then you can also go through, and this is probably a little bit more of a litigation type question, but you can go through a proceeding before the International Trade Commission, where you can effectively try to use your U.S. patent to stop the products from coming into the United States.
Okay. Good. And how do we protect our two examples? Like our air filter, that's if we're making it in the U.S. and somebody starts selling it in China, we can't do anything about it, right? That's the case.
Well, no, if you're making it in the U.S., you could stop somebody from copying it here in the United States.
Okay.
If somebody is making it in China, your patent limit, in terms of enforceability, you're limited to enforcing a United States patent within the United States.
Okay. All right. Before we continue, I wanted to take a break. We all know owning a shop is difficult, so we created My Shop Assist to help you manage the various jobs. Whether you run a machine shop, a performance tuning shop, build off-road trucks, or even do powder coating, My Shop Assist can help you. It is completely online and will help you schedule the jobs, log time on each task, track parts orders, and take pictures of the work. You can even export your jobs from My Shop Assist into QuickBooks as invoices. So if you're interested to improve operations at your shop, check out myshopassist.com to start your 30-day free trial. So what do we do with a patent once we get it? So obviously, like you kind of mentioned a couple things on here, like you can take that patent and you can sell it to somebody else. You can use it to protect your own product. So what do you do with it when you have it?
Okay. Well, once you get your patent there, you do have options for what you're going to do with it. If you're going to be manufacturing the products yourself, you have it as it provides you with the right to exclude others from making, using, selling, offering to sell, or importing your product into the United States. So it provides an opportunity to prevent others from copying your design or your product, but you have to go and enforce that right. It's not something that the government automatically does for you just because you've been granted a patent. You have to make that step to prevent others from copying it. The other thing you can do once you have your patent, if you decide that you're not going to be making the product, you can license your patent to another company. So say you've come up with on this air filter example, maybe you're going to license it to a company that specializes in automotive air filters.
K&N.
And you can approach them and say, I've come up with the latest and greatest air filter. Here's how it works. I've got it patented. I'll let you guys make it, and you can just pay me a royalty fee for, maybe it's a flat amount plus so many cents or dollars per unit sold. So you can provide you with a source of revenue that way. Or if you decide I don't want to work in this business anymore, you can sell it outright to another company and just pay. They can pay you whatever fee you can come up with that you think is fair and reasonable.
Okay.
So those are just some options you can do with it.
Okay. So enforcing a patent, assuming we have a patent for each of our two examples, how do we enforce a patent if somebody wants to copy the idea?
Okay, so if you think somebody is copying your idea and you want to enforce your patent rights against them, the first thing you need to do is you really need to do your homework and your research and figure out what this other company is doing. What are they out there selling? What are they out there saying? Start gathering your information. When did it first hit the market? What does it look like? Can you if it's like, say it's a competitive air filter, can you go buy a copy of it, from whatever store they're selling it? And so you can look at it yourself. And then you're going to want to contact your patent attorney and bring them all this information. And so that they can make an assessment as to whether or not they believe that there's a chance that this is infringing your patent. And so what your patent attorney will do would be to look at the potentially infringing product and compare it to your patent and the claims in your patent and see if that your patent would in fact be covering this product. And if so, then you kind of come to a decision point as to how far down the road here do you want to go with this other company. The first step would be possibly to send what's referred to as a cease and desist letter. And that is where your attorney would send a letter on your behalf just stating basically that they represent your interest in the intellectual property, that you hold patent number, whatever the patent number is, that covers, say, an air filter technology. We believe, based on your website, your marketing materials, the fact that there's actually products out in the store, that this product name blank infringes upon your patent number, and therefore we're requesting that you stop selling and making this product immediately. And then it starts to get into a negotiation process, because at that point the other side is most likely going to contact their attorney, and they're going to look at it and kind of push back and say, no, we don't believe we infringe. Our system is different. They may start to explain why. And you may try to just settle things at that point, one way or another. Maybe you offer them a license to your patent in exchange for a royalty payment if somebody is potentially copying your design. If you can't settle things out and you need to take the next step, that's where you're going to get into a patent infringement case by filing suit in federal court against them.
Does it go to patent court, or is it just a general federal court?
It goes to the United States District Court, and there's different rules about where you could actually file the case. But basically, if it's you could file it in your home district because that's where you're operating your business, and you could potentially file it in other districts. And your patent attorney will be able to give you more information about, if you ever get to that point, where you would want to file. There's certain advantages in certain areas, but you would file it in a federal court because of the interstate transactions that are occurring. It's not something that's filed in your local county court. And then the patent case is heard in the district court. And then if it's appealed, it goes to a special court, which is called the Court of Appeals for the Federal Circuit. And that's a specialized, effectively like a patent court, where they specialize in hearing patent cases.
Okay. So for most of our people, you're going to want to hope you get a settlement before you have to go to court, because I'm guessing the costs grow exponentially when you're going to court for this, right?
Patent litigation is very expensive, and so it's not something you want to take on unless you absolutely need to, or you cannot settle it. If you're the patent holder and somebody's copying your design, that you can't come to some favorable settlement with them. And then if necessary, that's why you have the patent, is to try to exclude others from copying your product. So.
Okay. What if one of our two products is the one or too similar to an existing patent? So how do we defend ourselves in that case? Is that a negotiation, or is you just drop the product, or explain that?
You can handle it a couple of different ways. So now we're on the flip side. So now we've received the cease and desist letter accusing the product we're selling of infringing somebody else's patent. The first thing you'll want to do is gather up the information you have relating to your design. They may, in fact, in the letter, they'll probably even include a copy of the patent so you can read it for yourself and kind of see how close this might be. But before you would respond is where you'd want to get connected with a patent attorney, have them do a detailed review of your product as well as the patent itself. The patent attorney is going to look into the patent and find out what statements were made during what's referred to as the prosecution of the patent, or when it was filed in the exchanges back and forth with the patent office, to see if certain statements were made or ideas were excluded, and if there's anything in the patent that could help you in the history of the patent that could help you try to get out from this. And you're going to need to respond to the party that sends you this letter. So it will be best to have your attorney do that on your behalf as opposed to you trying to respond. But once you connect with your patent attorney, they may be able to provide you with reasons why they don't think you infringe, or they may say, give you some advice, say, this is pretty close, this probably isn't worth fighting. Let's see if we can try to settle this favorably for a low cost. Also at that time, you also start to look at your design and say, well, could we redesign it slightly so that we get outside the scope of the claims of the patent so that we wouldn't be infringing it anymore, and we come up with maybe even a better air filter design or product, or we've changed it enough that they don't have a claim against us anymore, and we can just continue operating our business. Okay. So those are the things when you're on the receiving side that you'd be looking at.
Okay. So if a part covered by a patent breaks and must be repaired, can you fix it?
Generally, the rule is yes. You can fix a part that has worn out or has broken, but you can't fix it to the point that you would end up reconstructing the entire part. And what I mean by that is there's a doctrine of law called the doctrine of repair and reconstruction, and it's an issue that the courts have looked at as to to what extent you're allowed to repair something before you've effectively recreated it. And so if we take our air filter example and say that it's including a case and a filter material and maybe some plastic sheathing on the front and back that hold the filter material inside, and so it's got 5 or 6 parts to it. Well, let's just say that we got a hole in the filter material, and all we're going to do is pull out that filter material, put in a new piece of filter into the same case and into the same, other components that were used to hold it in place. You're just repairing it. You're extending the useful life of the product by making a simple repair. But if you're getting into the point where the casing has corroded and the filter has a hole in it and there's other problems with it, that you're effectively now rebuilding it from the ground up with other parts, but when it's done, it's effectively would meet the claims of a patent covering a new air filter, then you'd be reconstructing it, and going that far is not allowed.
Okay. And that would be considered a patent infringement, essentially.
That would be basically a patent infringement because you're now denying the patent holder the right by you rebuilding it completely and replacing it with all these other parts, it's effectively a new filter that would have been covered under the patent for it.
All right, makes sense. So it's common for people, and I've heard a lot of people say this, especially with particularly Subaru, but it's common for people to get cease and desist orders when they use major manufacturers such as Subaru or Mitsubishi for using their names on like web pages. So, for example, if you had a web page that said, "We are a Subaru specialist mechanic repair facility," whatever you want to call it, and they send you a cease and desist letter is basically what I think they're getting. But is that an actual violation, or is it a scare tactic? And I think this kind of falls more into the trademark and copyright issues, right?
Yeah, a little bit more under that. But basically, what you would want to do, if you have a specialty area in which you operate, it's okay to say that, but you want to include some type of disclaimer, because what Subaru's trying to get at possibly would be to say something like, well, you didn't have our permission to use our name tied into your business. And so you could say, as long as you have some type of disclaimer on there saying that, we're not an authorized repair shop of Subaru, or something along those lines, and your attorney can craft the necessary language depending on the situation and what your exact business might be. That typically is sufficient enough to prevent you from receiving those type of letters. They just wanted to make sure that it's clear you're not an authorized dealer of Subaru, or you're not an authorized reseller of Subaru, whatever it might be, or whatever business it might be associated with.
Okay, so you can use their name, just don't make it sound like you're representing them, essentially.
Yeah, you can use the name. You just have to make sure that it's clear that you're not an authorized representative of them, or you're not affiliated with them in any way.
Okay, perfect. Is having a record of inventing something prior to the patent being filed a defense against a patent infringement? So if you're inventing something, like before the patent was being filed or somebody else filed it, does that help at all?
There are certain rules under which information can help to invalidate a patent, and that is showing that it's been done before, it was publicly known. So let's say, for example, you're presented with a case where you're accused of infringing, your product is accused of infringing a product to, let's go back to the air filter, to this air filter. But you were working on your own design beforehand. Maybe you went to SEMA and you had a booth where you could easily show that it was on sale, information was out there publicly in 2013, but the patent application by the air filter company who's now accusing you of infringement wasn't filed till 2014 or 2015. If you can show that, so through having that kind of information that is dated, that shows that you were doing it beforehand, that you were publicly disclosing it beforehand. Maybe it was even in a form of a paper that you presented at SEMA on your technology, or at another trade show for a different type of industry. That kind of information can be used to show that this information was out in the general public. Okay,
so you can't just patent something that may not have a patent, because if somebody's already done it, it's not noble, right? It's not a new idea. That's kind of the idea there.
Yeah, generally the patent office, one of their jobs is to make sure that they're not just reissuing a patent on something that's been done before. So that's why they're looking for the novelty standpoint, to make sure that it is new and novel.
Okay, perfect. We've covered most of what we wanted to ask about the patent stuff here, and I'm sure people will have more questions, and maybe we can do some follow-up stuff on this. But I wanted a couple more questions on here. Can you suggest an action item for our listeners to take away that can improve their situation or maybe help them with protecting a product?
I would probably suggest kind of doing an internal audit of your own information and see is there anything unique that you've come up with, maybe that you haven't publicly disclosed yet, where you might want to try to file on a patent to try to help grow your business. Just kind of do a self-assessment to take a look and see anything that you've created that you might want to protect, but then also if there's any services you're providing, maybe it's in the repair area, to make sure that you're not infringing on anybody's patents. It's always good to kind of take a look at what you're doing in your business, pause, take a look at it, and just make sure if there's anything else that you need to just go back and double check, make sure clean up things. That's probably the best area.
Okay. And then I had another follow-up question for you guys. Is it common, or do people approach you to gauge whether an idea can be patented without actually having to follow through with the work?
Yeah, you can do, it's kind of referred to as a patentability study or a patentability opinion to kind of gauge before you go too far down the process and invest time and money into it, whether it's patentable or not. Now, that's it. Again, it's one person's opinion, and what we would do is we can do a art search for you, where you can give us the information on your design, and then we take that information and we search it at the patent office to see what other similar patents are out there or patent applications have been published that are in this same area. And based on a review of that, we might find something that covers exactly what you've done, and it was invented in 1975. And so the patent office is likely going to say, no, you're not going to be entitled to a patent here because it's been done before. Sometimes we don't find anything, but we find references that talk about similar aspects of technology. And so that's information that an examiner might put together to say, well, it would be obvious. And so we can at least give you a little bit of information up front to make that decision whether you'd want to file a patent or not. Ultimately, it's the client's decision as to whether they want to proceed or not based on some of the background information we can provide them.
Okay, awesome. So how do we connect with you and your company?
If you have any questions, feel free to give me a call. You can call me at area code 913-451-5100 and just ask for Brian Mack. Or you can go on to our website, which is www.lathropgage, LATHROPGAGE.com. And from there, you can search for my profile, and which will link you to my email address, and you can send me an email directly through our website, and be happy to talk to anybody who has any further questions.
Awesome. Hey, Brian, I really appreciate you taking some time to talk with us about this.
Thank you so much for your time. I appreciate the opportunity.
Thanks for listening to Do It for a Living. You can find out more about this guest, this show, and even details about what we just talked about at our website, doitforaliving.net. Check out the Facebook page at facebook.com/doitforaliving and tell us who you want to hear from. And most importantly, subscribe to the podcast. Click subscribe. Do it now.